So we've got a problem here that when you look at the second reason why they say Mr. Malema should go to prison, there is a disjuncture between what the state says and what the court found. My lady, you can't do this. You can't send somebody to prison for reasons that the judge did not find him guilty of. So this is the problem now with item 2. 2 firearms, 22 live rounds before 20,000 people. So in other words, the correct postulation is 1 bullet in a stadium of 20,000 people. 1. That's the correct postulation. And then ask yourself, in those circumstances, should I send this man to prison? And it's so absurd that they say, don't only send him to prison, send him to prison for 15 years. So it's like a game that they're playing. It's a game to inflame the passions of the public. Then the next reason why they say Mr. Malema should go to jail is, if you look at their supplementary heads, because he's a public leader and a role model. Now here, my lady, I sympathize with the state that we say, well, people that are holding positions of society should take responsibility and they should be good examples. But it's precisely the same reason that Ms. Thompson says you should look at Mr. Malema differently. And your ladyship, I want to remind your ladyship, when we were here during the evidence of Ms. Thompson, your ladyship commented, and they said, what's so special about him? The state says he's special. When we now say today, treat him through the prism of Section 9, everyone is equal before the law. So in other words, my lady, what we have is that for the state that chops and changes its case, depending on what it wants to achieve at a particular point in time. Today, they are trying to expand the realm of penal activity as expansive as possible. And then they say, okay, look at the fact that he's a parliamentarian. But when the witness was here, they said, no, his parliamentary position is irrelevant. He must be treated like everybody else. But a court cannot follow that unprincipled approach. Your ladyship must apply Section 9 of the Constitution, which says everyone is equal before the law. We obviously take into account that Mr. Malema must bear responsibility as a leader in society. We don't run away from that. But it's precisely because of that factor that we say, if you actually look at the fact that he has been criminally charged, it's a public trial that he's been undergoing. The fact that since the day of the charge, there is not even an allegation that he has ever attempted anything to do with the possession of a firearm. The fact that even before he was charged with these offenses, there is not an inkling that Mr. Malema had a propensity to possess firearms or to discharge them openly and publicly, recklessly, as the state tries to argue today. And the fact that the public trial itself has a shaming effect on the public representative. It has a shaming effect on the public representative because already people are saying, oh, well, why should he not lose his seat in Parliament? Why should he not lose his seat in the JSC? And the fact that, my ladies, the fourth part of it, is that we are not asking for a no punishment. We are simply asking for a non-custodial punishment. And no one can sensibly say that other forms of punishment do not constitute punishment, which is the zero-sum argument posited by the state. There is only one punishment as far as that concerned, is custodial. So what we say, my ladies, is that you have a range of penal options that would reflect the society's disapproval of, I would say, public misconduct by public representatives. And the custodial penalty, in fact, achieves the opposite. So we say that ultimately is a neutral fact that he's a public leader and a role model. The next one that they say you should actually send him to prison for is that he has no remorse. But they themselves say in Hewitt versus S, absence of remorse is not an aggravating factor. The state says that in paragraph 17 of their heads of argument. It's not an aggravating factor. But my lady, there is a fundamental legal problem with the argument. If an accused says, after conviction, I disagree with the magistrate, I'm going to appeal because the magistrate has wrongly found me guilty. The state says, infer from that he's not remorseful. It's absurd because even under Section 35 of the Constitution, he has a right to an appeal. And the right on appeal is based on a view held by an accused, wrongly or what, that the magistrate is wrong. You cannot say, I am going to punish this accused because he articulated a view that I am wrong. That is just an abuse of judicial authority. So he is entitled to say, I respectfully think that the judge got it wrong, and I'm going to appeal. The judges on appeal may say to him, Mr. Malema, it is you who's wrong, and not the judge. But in expressing a penalty, a judge cannot say, I'm going to punish you more because you've said it's absence of remorse just because you say, I do not agree. And I want to take this point further about the absence of remorse. They say, Mr. Malema has said these proceedings are an abuse of resources and the prosecutors are incompetent. That's what they say in their heads of argument. But my lady, if the prosecutor takes personal an accusation that they are incompetent, you know what happens? They violate Section 179 of the Constitution, which says that they must prosecute without fear, without favor, without prejudice. In other words, they must be prepared to accept the accusations and the criticisms from accused persons. They must not say, this accused person said that we are incompetent and therefore he must be punished more. Because that is not how the law works. The law works on a dispassionate basis. Whether someone has a loud mouth or that doesn't have a loud mouth, they must still be treated in accordance with the law. So we say that there is a deeper problem with this idea that because he said they were incompetent, therefore he must be punished, because it's not retributive, which is fine for sentencing, but it's vindictive, which is in conflict with the Constitution. So we say your ladyship cannot give an order that would be in violation of Section 179 of the Constitution. Then they say, this is now paragraph 18, where in B they said, it described the proceedings as an abuse of the NPA resources and an incompetent prosecutor, and that AfriForum was to be blamed. Again, we all know the history of this case, my lady. We don't have to repeat it. It is AfriForum that has been behind the prosecution of Mr. Malema.